So, shall I start now?
Yes, sir. Kindly let me allow to introduce you.
Okay, sure.
Right.
Yeah.
Rakesh, should we begin?
Yeah. Please start.
Okay. Very good evening to one and all. I, on behalf of the Newty University and the organizing committee of this international refresher course, welcome you all to the 4th day of the 2-week-long international refresher course. I am Dr. Manushi Chakraborty and I shall be your program coordinator for the day. I request you all, during any lecture, if you have any questions, queries, or comments, kindly write them down in the chat section of the Microsoft Teams platform. At the end of the lecture, if the speaker so wishes, he or she will answer your questions and initiate an interaction. We have 2 esteemed speakers with us today. The first lecture of the day shall be delivered by Sri Sanjay Bhattacharya, Deputy Controller of Patents and Designs, Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India. Mr. Bhattacharya passed Bachelor of Electrical Engineering from Jadavpur University in 1987. Between 1987 to 1997, he worked at different MNCs and PSU at different levels. From 1997 to 2002, Mr. Bhattacharya served as Scientific Officer Electrical at National Test House, Government of India, Ministry of Consumer Affairs, Food and Public Distribution, Department of Consumer Affairs. Since 2002, Mr. Bhattacharya is serving as Deputy Controller of Patents and Designs, the Patent Office, DPIIT, MCIGOI, and Head of Patents Office, Kolkata. The topic of his today's lecture is Patent Systems in India. We are extremely happy and honored to have you with us, sir, and over to you.
Okay. Thank you for giving me the opportunity. And, so now let us start my presentation. Actually, I'm with this office since 2002 onwards, and today I'm going to share my experience about the Indian patent IP system, and with main focus will be on patent, because I'm attached with the patent office and also the design registry. So today's I'm going to discuss my experience and what is the activities of patent office, Indian Patent Office. And before going to the detail, I would let us start with an example. Now, it is our idea that actually that IP concept introduced in our country from Western world. But that innovative idea and reward for innovation, that was actually it's a long practice, and the very good example Indian context is regarding how the game of chess was invented in our country. Now, chess is one of the oldest game. We know that it came into existence in 6th century AD. And then one Indian king, that he was having that idea or belief that war was the most effective school in which to learn the values of valor and decision making, endurance, circumspection, bravery, etc. And because of his idea like this, that he wanted that a game should be developed in which that practice of war can be done. And so he assigned this task, and finally announced there was some announcement that this kind of game or idea, if anybody is coming forward, so he will be rewarded for his idea. So now one saint of holy saint of Sisa, he was an Indian king, was name of the Indian king was Balahit. So now that saint, he just invented that game of chess, and he approached the ruler, and the king was very much pleased to see his invention, and he decided to give him a reward or prize. And then he asked that saint that how much what kind of reward you are asking for. You may feel free and ask me. I am very much happy with your invention, and I am ready to give you reward as desired by you. And then the man, who was very clever in nature, and asked the king that for the first square of the chess board, he would receive 1 grain of, or say, rice like that. And next, it is 2. That means double the first one. And fourth, for the third one, it is 4 numbers. So doubling the each and every box or square than previous box. So now after 64 box, when it is reached, that number of grains required to fill up that, it is 2000 crores of truckload. So this much of a huge, it is a huge demand from his end, but he was a very clever person, and he just represented his claim in a tricky way. And then the king was not very much that intelligent, or say, so he was a bit surprised, and he just he told that he asked that, saying that, are you sure that you are asking this? Why you are asking for such a trivial thing? And then he was a little offended also, and then he asked his, however, he insisted that I want that only. And then the king asked his treasurer to count and hand over the grain to calculate that. The ruler was annoyed that whole asset of innovation and the reward, that concept was known to us, and it was a very old practice. And however, in 1856, it was in a proper form. It was introduced in our country by East India Company, and first patent right was given to one invention, that is on pankha pulling machine. So with that, the journey of Indian IP system began. Now, what is IPR? Now, IPR means intellectual property right. Now, India is a country where we are having a population of nearly more than, say, 1.3 million. 1.3 billion. Now, there are so many people in our country who are having, who are creative, and they are having a lot of ideas, and they innovate so many things. Now, if you look about, if we talk about the film and music industry, it is there are a lot of movies prepared every day. You can say every day and throughout the year. And similarly, in some industry regarding, say, pharmaceutical sector, software industry, handicraft, textile industry, Ayurveda, yoga, and Indian space program, there is a huge progress after independence. So our country are full of creative people, and they're coming up with new ideas, and which are in turn changing our life. Now, India. Now, where is the problem then? Problem is that India is always an innovative society, and much of the intellectual property created remains unprotected. That is the major issue. Now, we are creative, but we are not well informed that my creation or our creation can be protected, and out of it we can have some commercial gain. Here it is Indian concept, or Eastern concept is that knowledge is free. It should not be. It should be shared with everyone with free of cost. But Western concept is something different. everything under sun is patentable. So that is the difference between mindset of our people and people of Western world, say in say US or Europe, like that. So that's why they are having a major share of IP. But however, since last decade, there is a significant last decade or 20 years, India signed so many treaties, and our IPR policy was enforced, and lot of encouragement in the form of a startup concept, and that facilitator for startup, etc. Because of that, we are made significant progress in the field of patent, also in the field of patent and as well as other IPs. Now, so actually that creative India, innovative India, this kind of drive has started 2016 onward, Make in India, Digital India, and we have made significant progress in these areas. Now, we are all aware about property, that is different types of property, movable and immovable. In this particular slide, there is examples of movable as well as immovable property. And then what is the difference between this movable, immovable property and intellectual property? Actually, intellectual property is nothing but product of mind or creation of human mind. Now, if it is artistic in nature, then sculptures, painting, etc., all are creation of human intellect. Similarly, other thing like say flag, parts, car, etc., these are also created in the industrial process. That is also a creation, kind of intellectual property, which are protected under patent, and there are some other protection also that is coming in the form of design, industrial design, and also that logo and brand name, etc., are protected by trademark. Now, what is intellectual property? IP means the property which created with intellect, such as inventions, books, paintings, songs, etc., symbols, names, images, like that. So, now you see that what is the why now we have discussed that about what is intellectual property. Now, next step is that what is the intellectual property right? Now, intellectual property right is similar to other property rights. Suppose when a person is purchasing a car, he is having some documents that that car has been sold to him by a automobile company, and against some payment and other documents, say road tax and insurance, etc. It is also handed over at the time of delivery of that particular vehicle. So similarly, he is having some document by which he can establish that he is the owner of the car. Similarly, a piece of land, when it is purchased by, there is a registry office, it is registered, and then ownership is transferred to a new owner. So it is like that. And similarly, that in case of intellectual property, how the one person will have that patent right. Now, patent right is a territorial right, and it is given by, in our country, that our government, that is government of India, is giving the IP right, all kinds of IP right in India, and patent right is one of the IP right which is also given in our country by government of India. So legal rights conferred on such property are called intellectual property rights.
Please.
Now, intellectual property rights are
Very good
the
evening to one and
protections
all.
granted to the
On
creator
behalf
of
of the
IP.
Nuclear University
Now,
and the
intellectual
organizing
property
committee of
protection
this international
mechanism is
literature
required
course,
to
welcome you
build
all
an
to the fourth
ecosystem
day of the
wherein
2-week-long
innovator
international
is
literature
rewarded
course.
for his
I am Dr. Manashi
creativity, and
Chakraborty,
he in
and I shall
turn
be their program coordinator for the day. I request you all, during any lecture,
brings
if you
his
have any
knowledge
questions, queries, or
into
comments,
public
kindly write them
domain.
down in the
So
chat
let
section of the
others
Microsoft Teams
take
platform.
advantage
At the
of
end of
his
the lecture, if the
this
speaker
knowledge
so wishes, he or
to
she will
bring
answer
further
your questions and
technological
initiate an
advancement.
interaction.
Now,
We
IP
have
shares
two
are
esteemed
territorial
speakers with
right
us
in nature.
today. The
And
first lecture of the day
suppose
shall be delivered
that
by Sri Sanjay
anyone
Bhattacharya,
is
Deputy
interested to
Controller of Patents and Designs,
protect his
Department of
IP
Industrial
throughout
Policy and
the
Promotion,
world,
Ministry of
then how
Commerce and
it
Industry,
is to be
Government of
done?
India.
Now,
Mr. Bhattacharya
the
passed Bachelor of Electrical
IP right
Engineering
given by
from
Government
Yadavpur
of India,
University
that
in
it is valid
1987.
only in
Between
India.
1987 to
Now, other than
1997,
our
he
country,
worked at
it is
different MNCs and
not
PSU at
valid.
different
So
levels.
now, in case
From
of
1997 to
anyone interested
2002,
to have
Mr.
his
Bhattacharya
patent
served
right
as
in other
Scientific
countries,
Officer
so
Electrical
he has
at
to
National Guest
separately
House,
apply
Government
in
of
all
India,
the countries
Ministry
where
of
he is
Consumer
interested to
Affairs, Food
obtain
and
IP
Public
right.
Distribution,
With
Department of
Indian,
Consumer Affairs.
suppose he
Since
is,
2002,
this
Mr.
applicant is
Bhattacharya
of
is
Indian
serving as
origin,
Deputy
first
Controller
he
of
can
Patents
file
and
in
Designs,
India,
the
and
Patent
with
Office
that
DPIIT
priority he can
MCIGOI
file
and
in
Head
other
of Patents
countries.
Office, Kolkata.
So
The
that
topic
way
of
he
this
can,
today's lecture is Patent
and
Systems
then
in
in
India.
each and
We
every
are
country,
extremely
according to
happy
their
and
IP
honored to
laws,
have you with us,
his
sir, and
application
over
will
to
be
you.
examined, and then they may or may
Thank
not
you for
give
giving
him
me the
that IP
opportunity.
right or say patent right in those countries. And here also his application will be
So
examined
now let
under
me
the
start
patent
my
act,
presentation.
and then if it is found that his
Actually,
invention is novel,
I'm
inventive, and having industrial applicability, and it is
with this
not
office
coming
since
under the
2002.
purview of and section 3, that is all his inventions are patentable invention, and it is not attracting the provision of defense and atomic energy, then his application will be granted. So now now financial benefit from what they invent or create, that is the motivation of an inventor or say applicant to create something which is new or novel. And what is his motivation or driving force is that if he is having a patent, and if it is having some commercially viable, then he can earn handsome money within the specified period of 20 years. And what is the benefit of the for public? Now you see we are under the pandemic situation since 2020. Now you see the vaccine which has been prepared. Now this vaccine, it is very much essential for us, because once we are vaccinated, we are relatively safe. That we are having, it will build up some immunity in our body, and we can combat COVID in a better way. So that is the benefit of the people, public in general, from one invention. So it is not only rewarding the inventor, it is also beneficial to the common people of a country, or say in globally also, if we think that it will be beneficial for all the people in this world to combat this COVID pandemic. So that is IP law should be framed in such a way that there is a balance. Balance is required, that if IP creators are not properly rewarded, then they will lose their motivation. They will not be motivated in future to create something new. And as a result, what will happen? Society as a whole will suffer from that issue. And at the same time, if that product or say process developed by an innovator, if it is so highly priced, then it will be not beneficial to the public. So there should be a balance, and there should be a specific period for which patent right should be given to an inventor. Now, what are the types of IPRs? Now, it is there are 6 different types of IP which is governed by our office, that is Office of the CGPDTM. It is a patent, then a trademark, and then industrial design, then copyright, and then GI, and then integrated circuit design. And there are some other IPs which is not under us, that is plant variety and biodiversity and traditional knowledge and trade secret. These are other IPs that is not under the jurisdiction of Office of the CGPDTM. And now let us come to patent. What is a patent? A patent is an exclusive right granted which provides the exclusive right to all others and prevent them from making, using, offering for sale, selling, or importing your invention. So it is basically giving the inventor a monopoly over his invention. And what is the criteria to be fulfilled for an invention to be patentable? That is, it must be new, it should be non-obvious to any person who is skilled in the relevant field of technology, and must be capable of industrial application. Now, a patent is valid for 20 years starting from the date of filing of the patent application, and it is not extendable. So it is it is for a period of 20 years, and after that it is in public domain, and it can be used by anyone. Now you see some examples of useful patented invention. Clever in nature. We are and after seeing that for the past square, this year in Bengal, that assembly election was held in the month of April, I think March and April. And all the time, at the time of elections, this particular item was used in each and every election. Say it is a local body election, or say in assembly election or parliamentary election, that product is indelible link, and it is used in largest democracy of the world, which is our country, and it was invented by National Physical Laboratory in New Delhi, and they gave license because it is a laboratories. They themselves are not engaged in manufacturing and setting up industry. Instead of that, they have given license. They are having some agreement with that Mysore Paints regarding profit sharing, and Mysore Paints and Varnish, they used to market this product. Now this ink is being used for election purposes for at least for the last 40 years in India and other countries. The ink is indelible because it contains silver compound which chemically reacts with the pigment of the human skin when exposed to light, leaving a black color on the skin. The ink is being used not only in India, but it is also exported to more than 25 countries. Even though patent terms is over, still it is very high demand, and it is not only used in our country, it is also exported to 25 other countries. Now, next is that remote control power tiller, RCPT. Now, remote control system for power tillers is developed for making the work of farming easier, comfortable, and safer. This is an electromechanical gadget which goes as an attachment for power tiller. This technology offers a farmer to operate the power tiller from a far point without even getting into the field and stand peacefully under the shade, avoiding exposure to elements and irritating engine noise. This also eliminates the chances of injury to the operator while running behind the power tiller in an uneven field. It is also quite helpful for women farmers. So this is the advantage of remote control power tiller, and this is the useful invention. And this kind of invention is making our life more and more comfortable day by day. So that's why that innovation and why it is required. From these examples, we can understand that this innovation or say invention is changing our life from present situation to a better tomorrow. So that's why we should encourage and these innovative people and creative people so that we can progress further in coming days. Now there are some, as I told, that there are some issues which is inventions. Those inventions are not patentable as per our act. That is the method of treatment of human and animals, and that is human inventions which is prejudicial to human, animal, or plant life, or health, or environment, and computer program parts say or algorithms which are protected by Copyright Act, and that presentation of abstract ideas. So invention contrary to the natural laws, so perpetual motion machine, and mathematical or business method, so method of agriculture, and other includes that inventions which are under coming under the category of Atomic Energy Act, and invention related to defense. Now, those inventions which are related to atomic energy and defense, we refer the matter to respective ministry, and if it is we get clearance from them, then we do the further exercise with those application. It is taken up for examination. But otherwise, what we do, if it is if we are asked, if we are instructed, if we receive instruction from DAE that this examination, this particular application violates the provision of Atomic Energy Act and it should be refused. So accordingly, this application is that application, particular application is not processed and it is refused as per the directive of DAE. Same is for inventions relating to defense. Now, this is another example regarding combination of different IPR. This relates with the TV remote. Now, an invention on remote control, when it occurred first, that a mechanism which can be protected for patent law, by patent law, for a period which is up to 10 years. And next is that particular, say it is a particular make, that particular remote control television set is a particular made by particular company, and make the name of that company is there. So that how it can be protected? This it can be protected by trademark, and then there is some manual by with the help of that manual one can understand how to operate that particular remote control device, that remote. So that is protected by copyright, and then that particular remote, it is having a particular shape and configuration and having some color combination which is protected under design, and a TV set that is protected by design, that particular or TV set itself also can be protected by Design Act, and period of protection is initially for 10 years and it can be further extended for further 5 years. So it is altogether it is 15 years. Now you see that it is a summary slide regarding the period of protection of different IPR. Now we are discussing about patent. So patent is initially 20 years from the date of filing. Now after that it is in public domain. It cannot be extended any further. And for design, it is initially for 10 years, and it can be further extended for further 5 years if it is request is filed before design registry office within 10 years period. But you see, for trademark, it is a different kind of IP, and that trademark importance of trademark is not going to end after, say, a specific period of time. As long as the company is in that particular business, his company's trademark is very much carries a lot of value. So it will, it is a perpetual kind of thing, and initially it is given for 10 years, and subsequently it can be extended after in every 10 years for further 10 years. Same is for geographical indication also, and in case of copyright for literary works, it is 60 years after the lifetime of the author. So semiconductor integrated circuit design is for 10 years. Or in case of plant variety, it is for crops, it is 15 years, and for trees and vines, it is 18 years. Now let us discuss about our organization structure. Our office is under the Ministry of Commerce and Industry, and it is the Department for Promotion of Industry and Internal Trade. And our controlling authority is Controller General, and under him there are 6 different IPs. And we are having patent offices located in 4 metros. That is one in Kolkata, and other 3 is in other 3 metros, that is Delhi, Chennai, and Mumbai. And Kolkata office is covering the whole northeast, eastern zone, and Andaman Nicobar Island. Delhi office is covering northern zone, Chennai office for southern zone, and Mumbai for western zone. And design office, there is only one office, and design that is in Kolkata. However, design application can be filed in other 3 offices, that is in Delhi, Chennai, and Mumbai. They are basically receiving office, and design processing and design registration and post-registration activities are carried out only from Kolkata office. For trademark, we are having 5 offices. 4 is in 4 metros. Head of trademark office is in Mumbai, and there is another office in Ahmedabad. For GI registry, it is located in Chennai, and for copyright office is in Delhi, Dwarka, and our integrated circuit design office is also located in Dwarka, Delhi. And we are having one Rajiv Gandhi National Institute of Intellectual Property Management, that is a training institute, and it is located in Nagpur. Now, our organization structure, you see that for patents and design, we are having the 2-tier structure, that is controller and examiners. And senior joint controller, deputy controller, and asset controller, they are all acting at par as per the delegated power of Controller General, and they are the ultimate authority to award that IP right to a patent applicant. And they are acting on the basis of the report submitted to the controller by the examiners. So it is a 2-tier system. Patent applications are allotted to a pair of controller and examiner. After examination, they put up the report online to the controller, and then controller review that report, and if it is in order, then it is communicated. Otherwise, it is referred back to the examiner for some addition or alteration. Now, when to file a patent application? Now, filing should be made immediately after the invention is developed for commercial working. Now, delay in filing may involve certain risks. Other invention of substantially same invention may take the advantage of priority, depriving the true and first inventor. And inadvertent publications of invention by inventor or others may damage the novelty of the invention. Patent should be filed before any kind of publication or commercial using of or communication to others. Now, why immediately after making an invention it has to be filed? Now, in case of copyright, if an author has created some, written some books, or he has given, he has created, he has just prepared a movie or like that, some or say music video. In that case, protection is automatic. But for patent, it is not so. Now, for patent, one has to file patent application before patent office for his protection of his IP right. So now, if he is not filing his patent application immediately after making something, creating something new, what may happen if it is noticed by someone else? He can take the advantage. Or there may be a situation, suppose all the companies who are in the same business, they are all the time they are doing some continuously doing some research and development in order to further improve. So if X is not immediately filing patent for their invention for protection before patent office, then Y may come up with that same idea and they can file that applications, and in that case Y may get that IP right. So that's why it is always advisable that one should immediately after making something new, creating something new, they should go and file patent application asking that protection for his invention, and with whether and when to publish. Now it is within after publication within 12 months it can be, one can file a patent, but it is always advisable you should file your patent application first, and then you can go for publication. So one should be careful that one should not, there is no bar after filing patent application, one can go for publications before grant of patent. Only you have to file your patent application first, and then you can publish it or you can commercially exploit your invention before disposal of your patent application. Now, where to file patent applications? Now, for Indian applicant, there is a jurisdiction issues there. Now, if an applicant resides in a particular jurisdiction, say what I have already discussed in my previous slide, when that Mumbai office is covering that Western zone. So any inventor or applicant or company which is whose business place is in Western zone, they are supposed to file in that particular jurisdiction. And in case of people of southern origin, they are supposed to go for and file their application in southern zone. Similarly, for New Delhi covering the northern zone, and Kolkata office is covering that eastern zone. Just a moment. Now, who can file that patent application? That the inventor himself can file any patent application, and assignee of the inventor. In most of the cases, what happens that a particular company, they are filing the patent applications. They are not natural persons, so they cannot invent. Now the employee who are employed in their company, they are making the invention and they are assigning their patent right, not patent right, they are assigning their IP to that particular company, and company is filing, being assigned that right, they are filing on behalf of those inventors. And they are holding the right because it has been assigned by their employee. There is some agreement among the employee that the IP created by those employee, it will be the property of that company itself. So, and legal entity they can also file, and by the legal representative of any deceased person. Suppose one person has some invention, and after that, before filing, he has expired. So, what will be the fate? Now, in case of any property, say movable or immovable property, property rights transferred from his legal heirs. Similarly, in case of IP also, his legal heirs will be enjoying this his invention, and they can file that patent application. Now, what is patentable? The invention in all fields of technology, whether products or processes, are patentable. And the main criteria for patentability is it should be new, and it should involve an inventive step capable of industrial application. Now, product means apparatus, devices, machines, and chemical products, drug, food, and their compositions, and then chemical compositions, biological products, etc. However, that it excludes that section 3 and 4 of the Patent Act. Now, it should be new or novel. So, it should not be, there should not be any prior publication or prior use or oral descriptions or before the filing date of the application. And there should not be any prior claiming or any other way, say in internet, it should not be available. Now, second is that inventive step. It should not be obvious. It should not be. It should be non-obvious criteria. Now, suppose there is an example of a say, string. Now, from string making, one can just prepare from using that string. One can prepare a James clip. Now, whether this preparation of James clip with the help of a string or where, is it obvious or non-obvious? It has to be judged, and if it is obvious, then it is not patentable. Even though it is novel, it is not patentable. Another example I can tell you that suppose if writing instrument, say a pen, when it was initially there was no cap on that pen, so one cannot keep it in the pocket. Now after sometimes in order to overcome that problem, one has invented a pen with a cap and clip, and then this is a very useful thing, and it can be protected. So it will be patent. It will get. It is novel and inventive, and it will be get patent protection. But after some time, suppose another fellow who is having a similar type of idea that he should claim a protection for a pencil with that cap. Now, whether it will be patented or not. In the second scenario, it is he is having that okay, he has applied the previous invention to another writing instrument, but it is obvious. So, on the ground of obviousness, second application is not going to be patented. Now, it should have that invention should be industrially applicable and capable of being made or used in that industry. Now let us come to the procedure of patent filing. Now, it can be patent application can be filed in any 4 offices in person, or it can be sent by post. And most convenient method of patent filing is through online. Now, in case of whatever may be the mode, one can file a patent application with that following contents, that a covering letter just stating that brief details that what are the contents of his particular applications, that is, and then that application form, that is called form 1, particular form. Then regarding some information in case of, say, it is having priority, then what is the detailed information that where in other countries where the same invention has been filed, and what is the processing details of that particular application, that is coming under, that is filed under form 3. And then proof of right, that how that inventor or applicant has got obtained the right of that over that invention, and it is required to establish that he is the rightful owner of that invention for which he is asking patent protection. And then now the fees can be paid by cash or DD or in other form. And patent specification, that is the complete specification or provisional specification. What is provisional specification? Provisional specification is that the immediately after making an invention, if he is needs some further research to do, then he can do. But if he files that provisional specification with or without claims for which protection is asked, he can just get that timeline for which now any person, after once that provisional application is filed, comes up with that complete specification on the same invention, then that person is not going not be given that IP right, because already provisional specification been filed by some other applicant. So that is the benefit of filing a provisional specification. And once an applicant file patent application with provisional specification, it will be a period of 12 months after by which one has to file the complete specification. And next form is the form 5, where the inventor details has to be given. And gist of the invention, that is the abstract, it has to be given along with that specification, and drawings when it is required. And if applicant himself is not filing, he is filing to some patent attorney, then power of authority to act on that on behalf of that applicant should be given to that particular attorney or attorneys. So these are the documents which are required to submit patent applications. And this is the form 1, and it is very simple. If any person himself is filing, he can just fill up this form. This is the name of the applicant and inventor's list of the inventor and title of the invention. And in case of filing through agent, his address, and if it is having some priority, then that priority particulars to be given, and then declaration of inventorship and all this, etc. It has to be given, and then that enclosures and that fees to be given, and then it has to be submitted. This is form 2. It is basically the cover page of the patent specification, and what are the contents of that specification? That is the description. The invention should be described in the best possible manner, and followed by the claim for which the protection is asked. So it is the most important part of a particular patent specification. where the inventor is claiming protection over his invention, and it should be properly drafted, because if it is not properly drafted, he may lose something, or he may ask something for which his invention is not related to. In both the cases, during examination stage, it will be pointed out, and in that case, he has to, if he fails to justify, then his patent application may be rejected. And what is the procedure of filing an application? Physical filing, that by coming to any of the patent office. And second one is, in most of the cases nowadays, we are receiving, say, around 90% or above patent applications through electronic filing. And because of this pandemic situation, and we are having, our country is a very vast country, it is very difficult for a person to personally come for filing patent application, or in case of sending a patent application by post, there is a chance of postal delay and other problem. If it is not properly delivered, then one can have the problem on so it is always advisable that one should go for online filing. And in case of online filing, we are encouraging the online filing. So there is a fee rebate for online filing. So it has to be, one can go for it. And this is our website, that is www.ipindia.nic.in. In that particular website, in home screen, there is a menu that is comprehensive e-filing. By clicking that menu, one person will get the guidelines how one can file that patent application online. Now, that what is the features of e-filing system? That is, it is very simple and simplified filing procedure, and you can log in with the help of digital signature as well as password based. Now, password regeneration procedure is also there, and there is a facility to upgrade the digital signatures also, and real-time validations with IPO database, and manage user profile and folders. These are the improved procedure to minimize transaction errors. So you see that by this e-filing, one can get immediate receipt, and there is no, and you are very sure that your application has been filed. And anytime during a day, one can file through our website. So that is very convenient also. And in fact, now we are having the provision in our patent that starting from filing to disposal, everything is online. So in case of applications which we are receiving through patent attorneys, and in case of expedited examination, online filing is mandatory. But however, for individual, one can come and just submit their patent application in offline mode. But it is definitely we encourage online filing, and the filing of all 30 different forms for patents, and request for examination, request for early publications, request for change of application details, that is filing of renewals of patent, and opposition, that is pre-grant opposition, post-grant opposition, request for certified copies, photocopies, information and inspection of patent documents, all can be submitted through online. This is online filing procedure. And this is a fee schedule. Now you see that filing fee for different categories of applicant. Now, in case of individual or startups or SMEs, it is 1600 when it is filed online and 1750 for physical filing. And in case of legal entity, it is 8000, and for offline, it is 8800. And if there is this amount is for total, if specific complete specification is within 30, number of pages is 30, and total number of claim is 10 or less than 10. In that case, it is 1600, 8000, 1600 or 8000, and in case of offline, it is 750 or 8800. In case it exceeds 30,000, then it is 160 rupees for each additional page. For individual and for legal entity, it is 800 when it is online. And for extra claims, it is 320 rupees for individual and 1600 rupees for legal entities when it is online. And for Form 9, that is the request for early publication, it is 2500 and 12,500 for offline. And now, there is an important point, it has to be noted that if an application is filed, now and subsequently within a period of 4 years of filing of that patent application, one has to file request for examination in Form 18. So if it is not filed, then this application will not going to be examined. It will be as abandoned. So it is very important that one should file request for examination. And now if an applicant is filing patent applications with complete specification, he can immediately at the time of filing can submit request for examination. And there is one expedited route for startup or and also lady inventor. So and other companies which are choosing India as ISA, they can go for expedited examination. And for expedited examination, it is 8,000 for natural person or and small entity or startups. But for legal entity, it is 60,000. And in case of expedited route, one has to process his applications online only. There is no offline facility for expedited examination. Hello. Now, what are the initiatives taken up by the government of India? Now, we are having IPR policy and we are encouraging that startup and small entities. And we are earlier there was our fee schedule was having 3 different categories. Now it has been reduced to 2, and startup and small entity has been clubbed with individual category. So, and that expedited examination process is initiated for startups, and in that this procedure can get his patent granted in a very short period of time, maybe within say 6 months or 1 year, if it is everything is okay. And second thing is that earlier there was we used to give 12 months time to file the response of first examination report. Now it has been reduced to 6 months, so that